Down in the shadows where the courthouse stands, a gavel cracks a fading hands. Judge Gould, they whisper with a crooked grin, played the game where justice don't win. Free Rick Allen, let him go. Chains on the innocent, don't you know? When the truth's been buried and the lies unfold, the fire in the people burns hot and cold. Prosecutor Mickelin with his papers tied wrote the tale that never saw light. Twisted words in a room of stone, left Rick Allen to stand alone. Who will answer? Who will pay? The sun don't rise on a judgment day. Free Rick Allen, let him go. Chains on the innocent, don't you know? When the truth's been buried and the lies unfold, the fire in the people burns hot and cold. Officer Holman, eyes like frost, drunk on power, the line got lost. Lock the doors, keep him inside, for justice limps where his footsteps stride.
Heyo, folks. It's Saturday. I survived yesterday. And today, well, we have some reading to do, folks. We have some reading to do. We are up to the motions hearing of May 7th, 2024. It is the first appearance of Jennifer Auger. And it has some controversy, at least in the eyes of Judge Gould. First of all, Oksana, thank you. Thank you. I'm not used to getting supers until I strongly suggest one. So thank you so much. that takes care of what probably will be a demonetized stream. Thank you so much. So it says, let's hear some Gould crap on this Saturday. Yeah. Yep, we will. Yep, we will. Sup, Nick? Well, coffee and me. I'm up. Good afternoon, Nick, chat, and Lord Commander Jingles. Yeah, I think he's outside right now. I think he's outside. Do we get to hear more of Trooper A. Holman? I don't know if Holman is here on this one, but folks, we are getting closer and closer to the trial. We are getting closer and closer to the trial. I forgot one thing. Hold on. I'm trying to get a person to come in here, help me. Oh, gifted 5 memberships. Okay, thank you. Thank you. Oh, we are doing unexpected today. And it went to Lady Voronkova. Oksana, hey, Oksana, you got a membership. Sadie Beans, Johnny Lunch Bucket, and Judge Mental. Thank you so much. Now you guys get all the members. You have access to all the members only content on my channel. You get early access on the videos I publish. You get your own emojis on YouTube's. And jeez, I have to fix that now. Hold on, my Discord. Hold on while I fix this. I'm not. Where is it? There. Dun, dun, dun. No, not that one. Hold on while I fix the. There. So on my channel, under posts for members only, fresh link to Discord. Just tell the mods who you are. If your Discord name is different than your YouTube name, just tell one of the mods. There. Now you should get access. Thank you so much. Thank you. Yeah, hi, unindicted. They're coming in hot, Mr. Nick. Yeah, they are. Thank you. I mean, majority of my Delphi transcript reads, those streams get demonetized. So all this is welcome. This is really welcome. Thank you so much. Johnny love your stuff, Nick. You're spot on and just like me. Yay! Oh, coffee. Yeah, this is the epitome of you can't un-F a cluster F. This Delphi trial transcript. It is taxing. So I was expecting myself to read every day. But I need to recuperate after I read some of this bullshit that is going on in this trial transcripts. So every other day or something like that. But now I have to step on it a bit because August 19th, in 10 days, the Donna Adelson trial starts. So I need to step on it a bit, or I need longer reading sessions. I don't know which of it will be. So, but we are here. I'm adding to stage. I'm going to put myself up here. And let's go. Record of proceedings at motions hearing held May 7th, 2024. Appearances. McClellan, Luttrell, Diener. For defendant, Rossi, Baldwin, Auger. Honorable, well, we can have a discussion on that. Gall and Jody L. Williams, who seems to be slightly hearing impaired. The court. We are in State of Indiana versus Richard Allen. Show that the defendant is here in person with Mr. Baldwin, Mr. Rossi. And I'm sorry, I don't know the lady at your table. Rossi, this is Miss Auger, Jennifer Auger, the court. Okay, she's the attorney that entered her limited appearance for digital forensics information. She did, Judge. And then there was an appearance that was entered a week or so ago that was a general appearance. The court, and I entered an order on that, and you should be receiving that shortly. It was a confidential order, states Mr. Rossi. With the court, I'm sorry, may I? The court, no. The states hereby Chief Elected Prosecutor McClellan, Mr. Luttrell, Ms. Diener. Yes, what? Well, to the extent that it might have an impact on what she can do at the hearing today, I was suggesting maybe we could approach the bench and you could advise us as to the nature of the order, just so that we're not crossing some boundaries that the court's not permitting us to do. Folks, with that, we actually have a guest. Hey, Mo.
Howdy.
Hey. I sent you the link. I was talking that something's missing. Oh.
I just got all of the ferals out to go on a canoeing trip, which I can only hope ends better than Gilligan's cruise did.
You will have a river reroute.
Yeah,
It
yeah.
might not go in the same direction anymore.
That I was like, sometimes handy capability is a blessing in disguise.
Oh, how are you doing? Well, I
Good.
haven't.
I haven't. I'm jealous because I haven't even gotten into Delphi because I wanted all the kids to be back in school so I could actually focus on stuff. And then Koberger dropped and Stearns has dropped. And I'm like, I need to find more time to read and retain that knowledge.
Yeah. And I'm a bit, because my planning for all of this Delphi, I expected all of this to not be public until after I got back from the States. No, somebody thought, we're all very happy because it saved us a ton of money that somebody at the clerk's office decided, fuck Yodi, I'm going to release this anyway.
Yeah, and the fact that, everyone's made it available, I think is really good. Especially, I mean, there are some people that are able to break it down like you're doing right now, and then some of us who, are trying to just keep up with everything.
Yeah, I mean, there are people who do highlights, which is great. There are people who, like me, I'm going to go through it all. And
Yeah.
I think all of it is needed because some people only want the highlights. And then you have me and my audience read it all. Read it all.
This is so dense, and there are so many things and moving pieces and parts, and especially if you're starting with the hearings that go through all the things we weren't allowed to see and the reasoning behind it, which I can only say that, look, we don't claim Judge Gull. I don't. I tried to vote her out. I'm not from Allen County, though, so.
Yeah. Yeah, and everything that, I mean, there's so much moving parts in this, and all of a sudden you realize, wait a minute, that case over there might be related to this case over here.
So did you ever get a chance to look into the Lyric and... It was Lyric and another name, but it was a case where the phones had been geofenced. So I think a couple numbers that had geofenced on Libby and Abby, or at least in the park, had also shown up with another case. And I want to say one of the kids' name was Lyric.
I have not been able to look into that at all, sadly. It's too many moving parts. I mean, as of now, I'm gathering information about Michael Fossler from Hamlet, Indiana. And yesterday I restreamed the interview with one of his victims from back in 1981.
There are a lot of things going on in Indiana as far as even prisons being built that just seems to be going a bit hinky here lately. So I wish I could say that we're trying to do better, but...
Oh, the Evansdale case. Is it that up in...
I believe so.
Yeah. The Evansdale case, it's there are numbers associated with, at least one number that's associated with the Delphi case that is also associated with 7 years earlier in Evansdale, where 2 minor girls were kidnapped and ended up found dead.
Yes,
I mean,
and it was interesting that it was a relatively public area, and then they were also found in a relatively public area. But it's one of those things
yeah,
that unless I can fully devote a lot of time, I don't
mm,
want to do a half-assed job because there are so many. I don't think people intentionally want to give out misinformation, but if you don't,
mm,
double check everything and your
yeah,
sources, you could inadvertently give out, the wrong
mm.
kind of thing.
Yeah, exactly. And that is what I'm trying to do with the Michael Fosler. There are what you call it fuzzy connections. He is the same age as Keegan Klein's dad. They have the same. Let's just say they have the same. What do you call it? Age preference.
Extracurriculars? I was going to
Yeah,
say bit files,
yeah.
hard drives.
I mean, and problem is all of that. The much about Michael Fosler has been scrubbed. There, and you need the connections that can be made is through their victims, and so far we only know of 2 of Michael Fosler. There is potential to be in the hundreds.
Yeah,
The
and
Keegan Klein's that family. Yeah, I mean,
yeah, there are so many scary things that we are learning as far as the girls' Venn diagram of shady people that they knew
yeah,
had a lot more than we were kind of, told about, and a lot more, kind of connections to a bunch of different tangents that should have been investigated. I mean,
yeah,
we're going through the Koberger and, oh, the Grubhub guy looked creepy. Okay, we pulled all of the stream from that. We talked to
yeah,
that. We talked to so and so. It's so
yeah,
refreshing to see an actual investigation.
yeah. And when you look at other cases that are going on right now, where they actually do investigations, and then all of a sudden you have the Delphi case, you have the Fosler case, and you have the Karen Reed case and the Sarah Birchmore case. We know people can conduct good investigations. Why did they choose to not do it here?
That's always been my deep down question
Mm,
because I feel like that's where we're going to get the ultimate answer
mm,
because this started from the beginning. I mean, you didn't the police chief not leaving the,
mm,
kind of nerve center to go out to make sure his people are okay to, again, this is one of the biggest cases that has happened in Indiana and the biggest case in
mm.
Carroll County, in
Yeah,
recent history. And you're telling me that you basically put the B team on and you stayed in and got radios?
mm,
Something's just been off about this since the beginning.
yeah. And it's infuriating because when you go through the transcript like this, you see and the motions, you see, why didn't you check that? Why did you just leave that? All that was necessary with some of the suspects in the Delphi case, take it one more step. And you could have either thrown it out but they assumed it would lead nowhere, so they didn't bother. And it's
Well,
minutes of somebody's time, and they chose to no, let's have a donut instead.
and that's what pisses me off about the moral high ground grandstanding of Leland of all of them.
Mm,
Because I'm sorry, but if you really cared, if you want to use these girls and say that you cared about them, then you should have put in the extra effort. You should have said, okay, I don't believe in the Odinist stuff, but let's take this to its conclusion. Let's,
Yeah.
let's turn over this rock, and then if we don't find anything, this is completely cut off.
Yeah. And then they know that they didn't follow it through. And then all of a sudden, here's Todd Click in 2024. Hey, have you thought about this information? And instead of, oh crap, okay, let's do our best. Let's get this over with. Let's investigate and then toss it. Oh shit, we have to hide this. I mean, and this Todd Click fellow, we need to send this guy to prison because we need to cover our incompetence. And I said, oh, for fuck's it's slightly annoying.
Yeah, it is.
But we are transcript. Can I ask of you that you maybe can do the part of the court?
I can. So where are we?
Let's see here. I have to. Let's do us a bit bigger. There. Let's see here. I just took care of. Why is my colors? Where's my color? Fuck. Where's my colors? Where's my colors? Okay. Well, we were at the court, the states here by the chief elected prosecutor, and then I was starting with Mr. Rossi here.
Okay.
So, Mr. Rossi, well, to the extent that it might have an impact on what she can do at the hearing today, I was suggesting maybe we could approach the bench and you could advise us as to the nature of the order, just so that we're not crossing some boundaries that the court's not permitting us to do.
You may approach. Look, it's as soulless as I can get this early in the morning. Well, in the afternoon.
Sidebar conference conducted.
I was not aware of a limit. I granted your motion for an expert. She is the expert, apparently, in digital forensic. The limited appearance was for that very limited issue, and then I see a general appearance. I don't know what that is, and I asked for an explanation. I don't have the order. It's not in the file.
Okay.
'Cause it's a confidential order, so no, I'm not gonna.
Well, she's not an expert. She's an attorney.
Well, she was listed as an expert in the field of digital forensics, Mr. Rossi, or Mr. Baldwin requests.
And then Jennifer Auger says, inaudible. Taking us to, I believe.
Yeah, for funds.
21st inaudible.
Oh.
Yeah, I'm keeping count.
Oh.
Yeah, we are at volume 4 and we have 21 inaudibles. And I know that Steve Gosney's record for one case is 125 inaudibles in total.
Indiana, I think, will beat that. Look, we have accents.
Yeah. I saw somebody already did a count. They did this, let's search for the word, and then did that. They cheated.
Oh, yeah.
They just counted it. I'm trying to catch all of them.
Gotta catch them all.
Inaudible funds?
Yes, for funds.
Oh, yeah,
And I approved that, no, and I approved that. I know she's an attorney, and then...
Yeah.
So she entered a limited appearance for that specific purpose, and then all of a sudden, I see a general appearance. I don't know what this is. I haven't authorized a general appearance. I authorized a limited appearance.
Thanks, Dave, for $5. Is Nick having a kräftskiva this month? No, he's not. I don't eat oversized bugs. I understand that. Yeah, I was
So that's
articulating to the court what the posture was to make sure we're on the same page.
I believe that we are, and I don't know what her role in this is going to be. I assume it's limited to digital issues that you've raised in the past.
Yeah, I think that was the original intent. And then obviously, because of the workload and the late discovery, which we're continuing to receive, which has just been the natural course of things, we felt like that we didn't want to be penned in when we got into court with her just being able to talk about that limited issue. We basically just, asked the court to recognize her as one of the attorneys on the case so that she can
Well, that's something that,
assist us in litigating at this late hour.
well, then that's something we'll have to discuss because I haven't approved that.
Sure, that's fine.
I approved a limited appearance.
I just want to make sure she's not doing something today that you're prohibiting her from doing. That's why I asked.
As long as she's limited to digital issues, then
Yeah.
I don't have a problem with that. That's what I've approved.
Yeah, I think that the confusion is this, where are the parameters in that sphere also? Because those are terms of art, and we learned all that in the last couple of weeks as we've, as we've done some discovery in this field. So, I mean, those are just some of the things. We can talk about it when we're finished today. I'm fine with that.
Okay.
Okay, very good. Thank you. Thank you, Judge, Miss Auger.
All right. The defendant filed a motion for a pre-trial hearing on April the 30th. I set that hearing for today so we could discuss the issues that you raised. Before you get to that, earlier this morning, Deputy Attorney General Aaron Rydlin appeared on behalf of the Department of Correction. The Department of Correction is a non-party, and the defense filed a motion to enter a stipulated protective order. I granted that motion and sent the order to the clerk of court on May the 2nd. For reasons that I do not understand, the clerk of court never entered it as an actual order of this court, and Deputy Attorney General appeared. I've provided him a copy of the order. I've had my staff go ahead and enter that order, and it was previously scanned in. I don't know why it didn't go in, but I had my staff then go ahead and enter that order, dated it. It is dated for May the 2nd. It was entered into CCS on May 7th. I provided a copy of that to counsel on your tables, so I don't know what the disconnect was, but I did grant that.
Judge, I spoke to Mr. Rydlin in the hallway, and he departed the courthouse because he felt like his business was finished today. So I think we're all on the same page about what we are trying to accomplish.
Okay, then you'll get a duplicated copy of the order then. Are you ready to proceed on your motion, Mr. Rossi?
Judge, I am. May I inquire as to are we dealing with the request regarding the scheduling issues, or are we dealing with the request or joinder for a hearing on the state's motion in limine?
Both.
Okay, well, I guess it's the defense view that if we're going to address the state's motion in limine, it's their motion, and so they would have the burden of proof to introduce what evidence they need to do. Make their arguments that the evidence should be limited, and then we would respond to that.
So you filed a motion for a pretrial hearing, but you do not wish to have a pretrial hearing?
I filed a motion consenting to the state's request for a hearing on the motion in limine.
Okay, so the motion for a pretrial hearing that you filed on April 30th, you requested a pretrial hearing to discuss scheduling issues associated with the trial, secured the appropriate amount of trial time for Defendant Allen to present a full and comprehensive defense, and to address any other pretrial matters that may be necessary.
Very good. I can comment on that.
Okay, go ahead.
Judge, obviously, we're looking at the trial calendar, and, the court had communicated with parties through an email indicating that this trial was going to commence on May 13th here in Fort Wayne, and that this trial was going to end on May 31st in Carroll County. And those dates, in my interpretation of the email, I think you used the phrase not more or less. They're not flexible dates. Those were firm dates that were going to be adhered in this case. And naturally, I understand that the court has not been a party to the exchange of the actual witness and exhibit lists because of the way the state and the defense have chosen to communicate. We filed notices that those witness lists were exchanged, but we did not share those with the court, so that they would not become public, at least on our side. And so I understand that the court may not have a full grasp in terms of the context of the number of witnesses that will be called and the amount of exhibits that would be introduced. With that being said, I think I shared with the court in the motion that, that I haven't counted them up to date, but I would say that each witness list at this point has over 100 witnesses. And that's probably half of those and are duplicated, the other half are not. In the normal course of a trial, I would expect that, only a percentage of those would be called. And so I don't expect the court's going to see 200 witnesses starting next week. But it's pretty obvious to me that the volume of witnesses and exhibits, at least in the opinion of the defense, would require, substantially more time than the 2.5 weeks that's set aside to present evidence. And with the defense going second, that puts us at a disadvantage, obviously, because we don't know how long it's going to take for the state's case. And so we got this problem of, okay, if you're going to limit the time that we have to introduce and put on evidence, are you going to split that time in half? Is there going to be some manner in which the court divvies up that time so that there's some equity in the process? I just practically don't think that we can do this in that short of a period of time. And that's even taking into the consideration that we're going to be working on Saturdays and maybe into the evening hours a little longer. I don't want to be in a situation where for 2 or 3 or 4 weeks or 2.5 weeks, we're sitting here and we're starting at the clock every minute. And so I'm looking for a practical solution to that. I think the defense is looking for a practical solution. I haven't had any conversation with Mr. McLeland about how long he thinks that it will take to present his case. But I feel like we both have a pretty good idea of the scope of the presentations. And I just don't see that we're going to be able to do that in that time frame. In terms of the law, that's applicable. I did lay some of that out for the court. I don't really feel like I need to sit here and make legal arguments. To me, it's more of a housekeeping or a business-related matter in terms of how much time the parties would need to present their cases adequately. But to the extent that the law is applicable, it seems to be pretty clear to me that one of the burdens placed on the court is that the court, before issuing any kind of, I'll call them restraining type orders or orders of restraint, where you're setting specific timeframes, that the court must be fully aware of the scope of the evidence that's going to be presented and the witnesses that may be called. And that's based mostly in federal law that is trickled down to the state, because that's where you get most of the regulation regarding the length of trials, and the presentation of evidence is in the federal courts. But that law is out there. And I'm not sure whether it's just, I think in this case, just because of the kind of nature of the communications between the parties, which we all acknowledge are, not the most streamlined. And at least I acknowledge that. And that's just the way it is, and that's fine. But we haven't had a lot of dialogue about what's ahead. We haven't had a lot of pre-trial hearings in terms of motion in limine and things like that. So I understand that the court doesn't have a really good grasp. At least I feel like the court doesn't have a good grasp on the scope of the evidence. And so I think it's a little premature to set firm dates without the court having a better understanding of what would be offered up. I think in September of October, we had a phone conversation. And I believe during that phone conversation, we were discussing the January 2024 trial date at that time. And I believe the court inquired to the defense as to what we are thinking in terms of time as far as the trial is concerned. And I believe I'm the one who actually suggested it probably would take us approximately 2 weeks, more or less, to present our case. I still think that's basically true. The words more or less matter a lot in cases like this, when you've got juries that could be sequestered for long periods of time. You're moving staffs from one jurisdiction to the other, I understand. There's a lot of logistical challenges that are on the court. But I still feel like our position hasn't changed. It's probably going to take us a couple of weeks to present our case. And obviously, with the May 13th through May 31st trial setting, Will part of that being consumed by jury instructions or voir dire? It just doesn't provide us with adequate amount of time to present our case. And I'm opining that the state probably going to feel the same way, but Mr. McLeland and his staff can speak for themselves. So we're just looking for some practical solutions to those problems, and that was the proper purpose for that order. And so that's the defense position.
Mr. McLeland?
They had a sale on Mountain Dew on Lidl. So I bought a case, and it's with the actual sugar, not the crap you have in it.
To be fair, Indiana is trying to take over with evil Judge Gull and high fructose corn syrup. God bless America.
Yeah, Judge Gull, she can be a high fructose corn syrup.
She's too bitter. She would be, she is the human equivalent to Malort, I have decided. She's a rite of passage. She's a pill we all have to deal with. And the weirdos really like her. But she's an acquired taste.
It's a kind of taste you want to stay buried.
Yes.
Okay, McLeland. Or if I take the attorneys and you take court and the female attorney.
Yeah, I can do that.
Yeah, and we will notice if it's unleveled. Attorney Nicholas McLeland. Now imagine me with hair plugs.
Actually, I think I have more testosterone than McLeland.
Yeah, a lot of people have more testosterone than McLeland.
Yeah.
Yeah. But I can't get away from those. It's so obvious hair plugs, and it's cheap hair. Folks, if you're considering hair plugs, don't go for the discount variant.
Yeah, don't fly to Turkey. It's just a bad idea. Look, if OnlyFans models can't get out of there alive, you're not safe with your hair plugs.
All right. Judge, we have done what we can to streamline our witnesses and exhibits that we plan to introduce. You know, I'm not really sure how to respond. The state doesn't have any objection to the 2 weeks. The state hopes to have its evidence done and concluding by the 25th. That's really interesting. They know that the firm end date is May 31st. And then they are saying, yeah, we will be done by the 25th, leaving them with 6 days minus weekend.
Yeah. What a prince among douches.
Yeah, how generous he is. That still leaves a whole nother week for the defense to present any evidence and any rebuttal evidence. How generous of you, Mr. McLeland. A whole week for both the defense case in chief and our rebuttal. What an asshole. That's our best guess with what we've got. Again, we tried to streamline it. We got it down to about 40 to 45 witnesses, and a handful of those, it's a half a dozen to a dozen, would be chain of custody type witnesses. We're trying to work through some of those issues with the defense in terms of stipulations and whatnot. Oh.
Yeah, so we just want to ignore the fact that the bullet was found 3 days after you opened the, crime scene to the public. And there's no photos of the bullet actually in the ground,
Yeah, and there's actually no way of determining when it got there. But those stipulations, that killed the defense. Because they did stipulate to, chain of custody. I think that is the absolute biggest mistake. Well, mistake by the defense, that is. I mean, there's loads of things in this case that are much, much worse, and all of it on the state. But that stipulation...
I think for the defense, I think that if they had And I know they have to bring up, the Odinist stuff and that kind of thing. But if they had focused down to the, nuts and bolts of this being a terribly investigated case,
Yeah.
I
Had they, I mean, I still make the connection between this case and the Karen Reed case. Hammer in reasonable doubt as hard as you can, and then just make references. Don't try to say they did it. Yeah. If they have another chance, I think this will go the same direction as the Karen Reed case. Because if they focus on the absolute horse shit that is the investigation, remember,
yeah,
folks, even if I believe that Rick Allen is factually innocent, that's not the standard they need to meet. All they
no.
need is reasonable doubt.
And you have to fight with children cases.
Yeah.
You do kind of have to give someone, like Dave always talks about, the monster to fight
Yeah.
against. And because they were so hamstrung, they really couldn't give that monster.
Yeah.
And regardless of what the jury, and I think some of the jurors are probably, now that they're seeing all the things that were kept from them, are maybe having some serious thoughts.
I hope so. I hope so. And since they are from, it's even if it's the neighboring county, it's more or less the same people.
Yeah, yeah.
And
And no one
you,
wants to stand up in front of the family of those two, past girls and say, look, I wish this was the monster. I'm sorry
Yeah.
you were told this was the monster,
yeah,
but we didn't feel it was.
yeah. And hope they might as well hope for what now when they know more, they also hope for the appeal. All right. We're trying to work through some of those issues with the defenses in terms of stipulations, but that's where the state's at. The state satisfied with the amount of time the court set aside? Of course you are, because you will have yours done by the 25th, and it leaves a couple of days for the defense. That's the only comment I have, Judge.
So, what is your request, Mr. Rossi? You're indicating I set this matter at your request for a speedy trial. You made your request March 6th, and on March 7th, I set the trial for May 13th to May 31st. And the first time I'm hearing that the specific dates are not adequate is April 30th in your filing.
Yeah, the defense request is that the court not bookend the back end of this trial to end on a certain date, that being May 31st. That the court understand that the presentation of evidence is just part of what professionals do in a case like this, and that occurs in a natural situation and a natural setting, and it ends when it ends. And to the extent that there is a need to, regulate those timeframes in a more strict sense, that we would sit down and maybe the court even consider requesting some or issuing an order that might further define the witnesses. Now that we're getting closer to the trial setting, and the discovery is getting closer to being completed. And then make a decision after Mr. McLeland, for the first time today, for example, just suggested they thought they had about 40 witnesses. Well, that's, 30 to 40% of the witness list that we received. So that's an indication of how fluid this case is. And so I would ask that the court either consider some further discussions with the parties to further define those witness list at the end of the week. But then at the end of the day, it seemed like we're kind of at the mercy in the term of how long it's going to take them to present evidence. And there's also rebuttal evidence that has to be taken into consideration as well. I think those things are not overly predictable, especially in a case like this. We got logistics in terms of getting experts to and from. Those will cause, I'm guessing, some further delays. And so what I'm asking the court to do is not set an end date for this trial, and understand that it's going to take more time. I would ask the defense be given 15 days of actual trial time to present its case. 15 working days would be the request by defense. And some of that's based on our predictions back in September and October of 2023. And having seen the witness list being modified over the last couple of weeks, because frankly, discovery continues to come in, and that's just the nature of this case. We are taking depots tomorrow. Yeah, this is May 7th, and the trial was scheduled a week later, and they are still receiving discovery and making
Yeah.
depositions based on the new discovery. It's insanity. And it is true, Mr. McLean mentioned that there are some stipulations that we're working on. Ms. Diener and I have been communicating in that regard to try and streamline some things so that we're more efficient. But at the end of the day, I think that we're going to need probably 15 days of courtroom time to put our case on, and that's what I'm asking the court to consider and grant.
Well, you understand, or well, maybe you don't understand. Jury Rule 4 requires I issue summonses to the jury with the dates of the trial. The specialized questionnaire that you all approved some months ago was mailed to the jurors, and you now have copies of those, hard copies at your request. You all came up and picked the completed questionnaires up. Jury Rule 4 requires that I issue summons to the jurors with dates. Particularly in this matter, the dates I provided to the jury is May 13th through the 31st. Jurors have been asked to arrange their schedules accordingly around those dates and times, and the rules require that I mail the summons to them at least a week in advance. I confirmed with the jury office that the summonses were mailed to your venue on April 19th, which was a Friday, and I anticipated that they started getting those summonses to appear on April the 22nd. So I've given the jury the dates that the trial has been scheduled for, and again, until now, I've not been told the amount of time you needed. I can't bookend a trial when I've already told the jury this is what the dates are going to be. You have a remedy, and again, I wish you could have informed the court well before April 30th that you didn't feel the dates that were selected at your request for a speedy trial were adequate.
May I?
Of course.
Judge, I appreciate that. This was a situation too where, frankly, the court never inquired with the parties about, what was forthcoming. That request wasn't made that I'm aware of. And, I think that might have helped solve some of these problems. But let's just pose the hypothetical. What if Mr. McLeland and the state's case runs into the 28th or 29th of this trial? So is the court going to allow us 2 days to put on witnesses, and then we walk in the morning on the 31st and you say, hey, at noon, if you're not done, we're done? We all know that's going to pose a problem that's going to end up causing this trial to be retried. There's no doubt about it. There's got to be some flexibility on the back end of this to kind of roll with the punches, so to speak, understanding that there are a lot of moving parts here. So I think under the court's current order, we're at the beck and call of the state. In fact, from a strategic standpoint, you invited them to put on a more verbose case, which might otherwise chew up our time and not permit Mr. Allen to, offer up an adequate defense. So how are we supposed to deal with that? I mean, I think it's just practically a problem. And I think it violates his Sixth Amendment right to come here and offer up to the jury a full, adequate, competent, and complete defense. And we're asking the court to reconsider the request for 15 days on our watch. Again, I said this back in September or October. I didn't say 2 weeks for a trial. I said 2 weeks for the defense's case. And I think you even suggested or mentioned that in the email or one of the orders that were issued. And so that's what I said. That's what we're asking for. I think our request is consistent with what we requested in the fall. And I'm asking the court to reconsider any thought of putting a drop-dead date on when this trial is going to end.
Well, then you need new trial dates, gentlemen and ladies. That's your solution. I cannot ask jurors that I've already tied in from May 13th to May 31st to extend indefinitely or for another 2 weeks after that time frame. Again, had you informed the court immediately upon receipt of the motion where I granted your motion for an early trial, had you notified me immediately, Judge, these aren't sufficient dates, I would have absolutely given you whatever time you needed on the court's calendar. I have no problem with that. I've tried hundreds and hundreds and hundreds of jury trials within the last decade that haven't been overturned. I have no problem with that. In my belief, 3 weeks, 3 weeks is adequate, or for a trial was adequate. Now I'm being told 3 weeks is not adequate. I have in my hand the April 30th, 2024 Defense Notice of Submission of Supplemental Witness and Exhibit List to the state. It's one paragraph. It's a notice to the court that you're exchanging witness lists. I have no idea what you're doing. And that's not my job to know what you're doing. That's not my job to micromanage attorneys. My job is to call the balls and strikes during the jury trial and to conduct an appropriate opportunity for the state to present its evidence and for the defense to present its evidence. Again, had you told me when you got the order granting your motion for a speedy trial that this is not sufficient time, I would have absolutely given you however many more weeks you were asking for. I hear nothing from counsel, nothing at all from either side, until April 30th. Your motion for a pre-trial hearing that this is inadequate time and now you're asking me to do something I cannot do. Under jury rules, I cannot give you that extra additional 15 days at the end of trial. I can't do it.
I believe, sidetrack. This is... This rule, you have to give the jury the time for them to schedule. That's why you never get in firm dates. So this is on her. For boom, these are the dates. Because she, in her turn, never checked with the state or the defense how much time do you actually need. Which is, she as a gatekeeper, that's her responsibility. She cannot just sit on her thumbs and just expect things. And I think this is the reason why she's overturned as much as she is. Because she is bad at her job. Oh, hello, Mr. Jingles. Hey. Where have you been? Why are you having stuff stuck in your fur? And that's why you're here. Yeah.
Out doing cat things.
Yeah. So, and once she heard that the state said, oh, we will be done by the 25th. Why doesn't she yell at the state? No, she's yelling at the defense. You should have told me. Well, why don't you yell at Mr. McLeland? Why didn't you tell me earlier that you were taking up from the 13th to the 25th? I mean, yeah.
Yeah.
All right, Mr. Rossi. So is the court going to divvy up the time equally, the time that does exist?
The court is going to ask you all to be professionals and stipulate to what you can stipulate to. If you're telling me that you're stipulating, I don't know what chain of custody issues have been arising between the parties. I have no idea what that is. Again, you've been very closed-mouthed with the court about what your evidence is. Other than the motions to suppress and the multiple Franks motions that you've filed and the state's responses hitherto, I get notice of submission, which is one paragraph that lists no information for the court.
May I?
Sure.
There is the court has sent out, I think, and produced roughly 450 jury questionnaires. My assumption is that we're going to voir dire in panels of about 50 at a time. I think is what the court suggested roughly in some of its instructions. One of the things that the court could consider doing is questioning the jurors as part of the voir dire, but whether or not they're able to spend more time sequestered to make sure that we can get this trial done. That might be an option. And to the extent that the jurors are not able to extend their calendars or their schedules beyond that May 31st date, then maybe they would be struck. I think 450 jurors is going to be more than enough. And I think we can find in that pool people who are willing to stay and serve the interest of justice and their civic duties without burden. So that might be one possibility in resolving this circumstance. I'm still not sure, even under the current schedule regime or judgment, I should say, I'm not sure that I'm aware of how we would present our case, again, if our time is consumed. You're not telling me how we're going to solve the problem if the state's case takes longer than that. They haven't even told you how long it's going to take, except for, well, it might be a week. We're not really sure.
Well, he indicated 45 witnesses approximately.
Judge, yeah, what the state did is we took the time the court set aside for the trial, and we tried to, I guess I'm going to use slang terms a little. We tried to cut the fat as much as we could and streamline this in the most efficient way we could. Now, we can't predict what's going to happen and how long the testimony of each witness is going to be. We tried to predict that, and we tried to fashion our questions and our witnesses, again, in the most streamlined way possible, knowing that we were set in that allotted amount of time. And so we cut witnesses in that respect in order to present our case as efficiently we can. And so that's what we've done, Judge. And I believe we're around 40 to 45. That may be reduced, depending on what we can stipulate to. We may have to throw a witness in there if we can't make some stipulations. But we've done our very best to, again, cut as many witnesses as possible while still meeting our burden, Judge.
God, Brown knows any harder, McClelland?
No.
Jessica, I love you. Also, you look beautiful today. Also, did you get the chocolates I sent and the booze?
That's why he has the tan on a can, because he has to hide the color of his nose.
So your suggestion, Mr. Rossi, is to proceed forward and hope that the jurors that we have summoned can give another 3 weeks, which means the court has made arrangement for the jurors for lodging, transportation, etc. And you're asking me then to extend that? What if I can't? I've entered into contracts with vendors. Well, not contracts with vendors. What will the Constitution do?
Yeah. Oh, no, the contract. Oh, it's... Your
Not the best Western.
Judge Gull, your inability to plan does not constitute an emergency on the defense. Ms. Rossi, well, it sounds like the court just invited me to move to continue the case to another date. That's the way I interpreted what you just said a few minutes ago. Which would kind of run afoul or run in the face of you having all these things organized. I understand that. That's why we're here having this professional discussion about time. But you're not hearing anything from the state that's suggesting that it's going to take them a week. He is saying we're trying to streamline things. Well, that's not real comforting when you're sitting over here and you're on the receiving end of that, So I'm not hearing anything from the courts that's confining the state to any specific amount of time. In fact, it's almost like you're not willing to do that in the context of this. Oh, Mr. Rossi.
Pointing out the obvious.
Pointing out the obvious, that Judge Gull is more or less telling them, that speedy trial thing, if you just remove that, I will accommodate you. Yeah. Because those firm boundaries, no, it's stupid. Which suggests to me that they can sit there and put on evidence until the cows come home. And I don't want to be in the situation where we just stop one day and we tell everybody to go home and we'll see you again in the fall. We're going to do it all over again. This just doesn't make any sense to me. And I've never been involved in a situation ever. And I understand this is a unique circumstance. But I've never been involved in a situation where a judge set an end date and not only said it's not going to end sooner or later.
Excuse me? You've never had a court set a trial date for you is...
I've had a court set...
that what you're telling me?
Starting dates. But I've never had a court tell us it's going to end on May 31st, no more, no less. Those were the words of the court in this case. I've never had that happen, which is one of the reasons why I filed the motion. And look, we're practicing in different areas of the state. Doesn't mean that what goes on up here is, better or worse than what goes on where I make a living. But that's the reality. That's
a shocking reality, Mr. Rossi. I have never heard any of my colleagues give open dates for trials. I'm surprised that that happens routinely across the state of Indiana.
Judge Gull, that happens everywhere, except apparently in your court. Ms. Rossi, well, in the...
Because in this court and in my experience with my colleagues, you get a trial date. Here's your trial dates, May 13th to May 31st, period.
Mr. Rossi. Yeah, well,
So your experience is vastly different than the court's.
and that's fine. The problem is we have to deal with those things and find some solution. And I'm asking the court in this case to recognize his right to put on a defense is just as important and frankly more paramount than their right to prosecute.
I don't disagree. And again, I wish you would have let me know.
And so by pinning us in, it almost seems like, I used the word invite earlier, it seems like we're inviting them to make his situation, Mr. Allen's, more untenable. And I don't understand that. I don't understand how it is that the court, couldn't reach out to the parties before the court issued the order setting the date, saying, hey, I'm getting ready to issue an order setting dates. 2 weeks going to be enough? 3 weeks going to be enough? A month? I mean, a lot has occurred since September and October when we talked. And so, it seems like to me that why that didn't happen, I don't really care. I know that we're dealing with the circumstances as we are sitting here today. I just want to get the problem fixed, and that's
Well, it happened, sir.
for the court to consider.
Because I don't feel if I email, my emails end up in pleadings. Obviously, we can't have a 6-way phone conversation, and emails end up in pleadings is not how I do business. So I do business in written orders. I gave you an order granting your motion. Now you're telling me it's insufficient. Again, I don't know what you want me to do. I gave you a set of trial dates. I've always given you a set of trial dates. You've never indicated that those dates were inadequate again until April 30th. Then we sit here now today. So
Can we have a 5-minute recess, please?
why?
I would like to speak with my co-counsel here and have a discussion about the business issues such as scheduling, not here in the courtroom where everybody's listening to us. We got, 50 staff members in this courtroom, people sitting behind. There's no privacy. And I'd like to talk to him in the hallway about some of the logistics of this so we can solve this problem so that Mr. Allen, can put on a defense.
Does the state have any objection to a recess?
No, Your Honor.
All right, Jody, you can go off record.
Oh, and by the way, when in the earlier transcripts of pre-trial hearing, she only sets one trial date, the beginning, in the earlier hearings from 2023. She doesn't set an end date on the trial, only a start date. So she's lying.
Well, yeah, but she's adding just enough of that willful obstinance, that willful non-listening. Like, you guys asked for 2 weeks. I put 2 weeks in there, and then you didn't look at my homework, and I wasn't going to grade you.
Yeah, and she said, oh, but you said 2 weeks. Yes, our case 2 weeks, not the entire fucking trial.
Yeah.
But again, that is her either
Well,
not
but how does
listening
a person-
or actively just putting obstacles in the way.
Well, she's actively not listening to the defense. That earlier soliloquy where she's like, so I don't understand. We have a pre-trial motion, but I already granted your motion. And he's like, no, you granted an end date. We don't have. So why are we here?
Yeah. And I think that's just the way she works. When she discovers that she fucked up, she ignores it and pretends. And then she lies. Because she knows attorneys are really, really hesitant on calling a judge a liar.
Yeah.
Did you just put something on your screen?
I just zoomed it up, so it tells me
Okay.
how many times I'm zoomed in.
Okay. I mean, are you putting a hat on yourself? What's going on over there? Okay. Off record, 9:32. On record, 9:42.
All right. Have you had adequate time, Mr. Rossi,
Yes, ma'am.
to have some discussions?
Yes, ma'am.
Okay, I note in your motion for a pretrial hearing as well that you had indicated in your paragraph 15 that this case doesn't present itself to the court as a case of first impression, at least not from a scheduling standpoint, and you are correct in that. I did preside over a case of the state of Indiana versus Bob Leonard, which was a case venued from Indianapolis, Marion County in 2016. I think it was commonly known down in Indianapolis as the Richmond Hills explosion case. That case was set for trial. You are correct, for 34 days with nearly 140 witnesses. What you didn't include in your petition and your pleading is that the case was actually tried by this court in 20 days with 161 witnesses and over 2,000 items of evidence. I also tried State of Indiana versus Cohen Hans Barron, a life without parole with an individual who murdered his girlfriend and her 3 children. We tried that in 7 days with 36 witnesses and over 200 items of evidence. Bryce Pope was a life without parole case that I tried in 4 days with 2 victims. Dustin Neal was a 2017 murder that was tried in 2023. I tried that in 4 days. I tried a death penalty case earlier in my career in 2.5 weeks with 4 victims. So I am experienced in scheduling matters for trial, gentleman and lady. Again, I've given you the opportunity to consult with counsel and co-counsel to kind of see where you're at and to speak with Mr. Allen. What would you like to do, sir?
Judge, first things first. To just make a record that we did have a chance to speak with Mr. Allen in the jury room.
Okay.
And I appreciate it. Some sense of privacy in that regard. I would like to note for the record that we have security staff standing next to us when we're talking to him. We are not permitted to talk to him in private. There are 2 gentlemen in there. I'm sure nice gentlemen, sure doing their job, but the idea that there's any confidences that are communicated to our client in this case is it's not true. And that hasn't been the case throughout. It wasn't the case a few minutes ago when we walked in that jury room and had people essentially standing next to us when we're talking. The same was true when I was here a few weeks back, a month or so ago, when we were out in the hall. We were offered up a spot in the corner of the hallway to talk to our client while security staff stood nearby. And I'm asking the court to consider in the future to allow us to spend our time with some form of privacy. I would appreciate that. Sergeant Jeremy Tinkle?
We can certainly take him down to our office and they can talk to him while he's in the holding cell. Can we do that? Yes, we can. Okay, you can do that right now if you want to speak to him privately.
Well, it's too late. We just had this conversation knowing that we had limited time, and I didn't want the court to, we knew we had to get back in here. I asked for 5 minutes, so...
Sergeant Tinkle has informed me that you may speak with your client privately down in their offices.
That ship has passed. Okay. I appreciate the offer, but it doesn't make any sense for us to go back in there and talk about what we just talked about. I'm asking the court to consider moving forward that we be given some privacy with our client. Second, what we're requesting for the court today is 15 business days to present our defense.
Okay.
15 business days. We believe that that's the amount of time it will take us to present an adequate defense on Mr. Allen's behalf. Third, to the extent that the court is inclined to deny that request, then we are asking the court, we're moving to lift our speedy trial request, and we're asking the court to give us a new date in earnest, when the court can set aside the adequate time that we requested to present our case. What the state does, that's on them. They can ask for however much time they need, but we're asking for 15 days.
Mr. McClelland, I'm sorry, were you done?
I'm finished. Mr. Baldwin would like to speak. And folks, mistake again from the defense. They are themselves lifting the speedy trial. Now, it's the same kind of coercion as in when they were disqualified. But it's still, with that knowing, don't volunteer things. Make her do it. But I understand why, because you really want your client out of that fucking prison. So
Yeah,
I
but I
understand,
almost
but I
wonder.
still say it's a mistake.
I almost wonder if they shouldn't have pressed the speedy trial. I know that he needed to get out, but they played into Gull's hand. Then
Yeah.
she could really, really put her fingers on the scales.
Mm.
But I don't know that it would have been any better with more
Yeah.
time.
No, because at this time she hadn't ruled on the third-party culprit. That came later. And this was just a week before. She was probably already planning it.
Yeah.
But yeah, so it's impossible to say now.
Yeah, you're kind of damned if you do, damned if you don't. I mean,
Yeah, and as Mikko says, Rick was about to die at this point. Yeah. Attorney Baldwin. Judge, we are filing a second request for you to be disqualified in this case. I have that here. It will be filed by email as well as or by filing. May I approach?
what do you have?
A motion to disqualify you as a judge on this case.
Oh, okay. It needs to be e-filed.
Okay, would you like a paper copy?
No, I can get one when it's e-filed.
Okay. I have nothing further.
Mr. McClelland?
Mr. McClelland, Judge, in terms of the response to defendant's motion, I guess I'll just focus on the lifting of the speedy trial setting and the trial date. Judge, we'd leave that discretion to the court. Of course, it's frustrating. We're ready to go on the 13th. We're ready to move forward, but I would leave that part to the discretion of the court in terms of the defense. Second verified motion to disqualify, Judge. It's 24 pages, Judge. I haven't read through it. I don't have any response to it at this point. So I just leave it at that, Judge.
Well, he hasn't e-filed it, so when it gets e-filed, you'll get the opportunity to file your appropriate response.
Thank you, Judge.
So you're waiving your right to a speedy trial then?
Yes, at this moment we are.
Okay, and you're asking for 15 business days? I've looked at my calendars and we were originally set in Carroll County October 14th through the 31st. If you're requesting an additional 3 weeks after that, we can go October 14th to November 15th.
Is the court granting a request for 15 days for the defense to put its case on within that time frame?
If you can't try this case in a month, gentleman and lady, there's something wrong. I see no reason that this case can't be tried in 30 days. We'll work on Saturday. We will. The schedule that I've previously provided to you in an email some month ago, I see no reason that can't happen in that time frame.
See here, she's blaming the defense. She's telling them, if you can't try this case in a month, gentleman and lady, she's directing this to the defense, not the prosecution. Now, 30 days is an insane amount of time, but this case they have to prove something with no evidence. So everything is extended from the state. And the defense has to act on what the prosecution does.
Yes.
And of course, if it's a clean trial, then it takes days. I mean, what was it? 2 months ago, I covered another Georgia murder trial. 3 days, because they had good evidence. 3 days for a murder case, including that the defendant took the stand in his own defense, which was hilarious. This absolute nobody claimed that they have a bounty, $50,000 bounty on my head. Nobody values you at 50 grand. Not one. Mr. Rossi, you don't know anything about this case. With all due respect, Your Honor, you haven't seen a witness list or an exhibit list.
No, I have not.
So I have no idea how you can have any context for what is involved in this case. And the discovery continues to come in, because every day that he sits in that hole down in Wabash County, there's new evidence that's presented.
So are you...
By way of 24 hours of video, camcorder video, medical records, psychiatric records, how would you possibly know? We haven't had a pre-trial hearing on any substantive issue in this case. You have summarily denied everything we put on your desk. How would you possibly know how long this case is going to take to try it? It's beyond me. I don't understand how that could possibly be.
I have 27 years of experience on the bench, Mr. Rossi, trying multiple high-profile homicide, life without parole, and death penalty cases. Are you telling me that 30 days it is inadequate for the state and the defense to try this case?
I'm telling you that picking an arbitrary number does not make sense. What makes sense is having the parties have discussions, maybe in an open court with a scheduling hearing that would be ordered. And about really how many witnesses are coming, really how many exhibits are you putting in, what are your logistical challenges, those kind of things. And then we can come to some conclusion on how much time it's going to take.
Well, then why don't you have those discussions and let me know that you can't physically do it in 30 days? I'm waiting.
Because we are not talking. It's probably pretty obvious at this point.
Oh, it's patently clear.
Yeah.
To me, Mr. Rossi, that the defense team and the prosecution team are dealing with each other only in written form.
Yeah, folks. And you know why? Because the prosecution keeps lying. So the defense needs a paper trail. They have been catching the prosecution lying throughout. From the day the defense got this case up until this day, they lied. They lied about the 70 days missing. They lied about the Purdue professor. They lied about how he was treated in prison. They lied about everything in this case. So eventually, and this with Judge Gull claiming incompetence and unprofessionalism and everything. All right, everything in writing, because we need a paper trail. Mr. Rossi, email only is the instruction we've been given from the state. And so the line of communication is somewhat broken, and some, to the extent that those problems could be solved, they could be solved by ordering the parties into a courtroom to have constructive conversations about scheduling, which did not occur.
Well, we're all here now. Why don't you have those discussions?
Well, we have been, and they're not bearing any fruit. We made our request, 15 days to try this case. We're moving to lift the speedy trial motion. My simple request is, how much time between October 15th and November 15th will be dedicated to the state's or the defense's case? That's what I'm asking.
Mr. McClelland?
Judge, I can't give you a definite day of how long it's going to take us to present the case. The burden is on us. When I presented to the court before that, I thought we would be done by the 26th. Yeah, giving the defense 5 fucking days.
Yeah, nice try.
Yeah. That was taking into consideration the time the court has set aside for the trial. And that's only taking into consideration how long we think it'll take to do direct examination of the witnesses. No idea how long it's take for cross-examination. Yeah, folks, they were scheduling from the 13th to the 25th without cross-examination of their witnesses.
This is so... you couldn't sell this to Hollywood, because people wouldn't believe this corruption was real.
No. But if you remember the YSL trial, the prosecution did the same thing there. How long do you expect this to take? This amount of time. And then when that time had passed, why? Well, we didn't calculate how, the cross-examination to be this long. For fuck's sake. "5 days for a double murder is beyond me." Well, if you have them more or less on video, It kind of,
Yeah,
yeah. Then it's 2 days of, yes, those two are really dead. Here are the pictures. 1 day of, yeah, that person. And then a day for the defense, and then some rebuttal, and then closing arguments. So 5 days. Much of many trials are about proving a person is actually dead. Surprisingly amount of time. I mean, just look at this Nicolas Croissant case that is going on now. What's his name? The Doug Weinstein's new case.
oh,
I mean,
yeah,
they have
I've
spent 4 days telling the jury that she's dead.
well,
Yeah.
I mean, it was a slight case of decapitation.
Yeah, with apparently, what was it? It's with a shit knife. That apparently the state can't even say that is the knife that was used. It was just found nearby. And he happened to buy the same knife, I believe, the day of the discovery of the body. So they are trying to make it, well, he lost that knife, so he had to buy a new one. Yeah, or he just went to buy a knife because he had stuff to do.
Yeah, he's not in
It's a really
England. It's
no.
not illegal yet.
Yeah, and that case is really strange because, yes, that Nicolas Croissant, whatever his name is, he's an asshole. And he's a liar. It is Murdoch with less evidence. I mean, he is really, really a talker and a despicable person. But the evidence, I mean, this, according to the prosecution in that case, took place in an Airbnb, in a $500,000 house.
Mm-hmm.
Where's the surveillance cameras?
Yeah, in an Airbnb in that high level of a property, you're gonna have surveillance.
Yeah.
Your
But
insurance, I would think, would require it.
yeah, but so far at least, no surveillance from the prosecution. Because it would be really easy with surveillance to see, there he is, carrying stuff out through the car and taking off. Oh. Thank you, Nick Kasotis. Oh, so it's a Greek name, not a French name. Thank you. The circumstantial will, yeah. I mean, it is a combination of Zachariah Anderson and Murdoch. You have a completely despicable person, but no evidence he was actually doing it. So they have to go with circumstantial. Look what an asshole he is, and he lied and everything. And we found a knife that maybe matches, and the blood that we found in the Airbnb should be like 5 times as much. And don't bother with the unknown blood that was there as well. I mean, it's.
So, like the hair wrapped around the finger that got tested a week into trial
Yeah.
for this case.
It's Jesus Christ. Or yeah, no idea. Oh, look, I can do color again. I wonder why I couldn't before. All right. And so I'm not willing, from the state's perspective, to say, okay, Judge, give us this amount of days to put on our case. Judge Gall, this is when you're supposed to yell at them. But you don't. Because it's hard for you to stare down with him between your legs saying, stop doing that. I understand that.
Yeah. But at least not in public. You could wait until you're back in chambers, both of you,
Yeah.
for the love of Cheetos.
What I can present to the court, what I wanted to tell the court, is that we're going to present our case in the most efficient, fast way we can with the time allotted from the court. It is not our intention to take the time given by the court and take up every single day so the defense doesn't have an opportunity to present their case. However, we have the burden. But we are going to take the time the court gives us and do what we can to make it as efficient as possible. not only for the state, for the jurors, for the witnesses that are involved. We're going to do our best, Judge. But I'm not willing to sit here today and say, give me 7 days, give me 8 days. That's just not something I can do, Judge, because I don't know the extent of cross-examination of the witnesses.
So, Mr. Rozzi, Mr. Baldwin, I will grant your motion to continue the jury trial and order it reset for October 14th through the 15th
Of
at
November.
8:30. Oh, okay, because I was like, well, now she's just giving him a day. Talk fast, McLeland. Beginning at 9 o'clock every morning down in Carroll Circuit Court. Show that you've withdrawn your right for a speedy trial. While you are all here, do you wish to schedule a pre-trial hearing, or do you want to address we can set up pre-trial hearings? And Mr. Rozzi and Mr. Baldwin, when the court summarily denies motions that have been filed, it is the court's belief that there is nothing within the pleadings that have been filed that require a hearing. So if you wish to have a hearing on your various motions to suppress, I would entertain that. When would you like that set?
And spoiler, they did a lot of motions, and she denied more or less everyone without a hearing.
Yeah.
She kept doing it, because she didn't want a hearing. Because motions are written, here's the sum of it. And then they argue, they are witnesses. You don't know exactly what witnesses are going to say. She couldn't risk the state's case being fucked up.
Exposed.
Yeah. Mr. McLeland. Judge, while they're looking at their calendar, I'm sorry, Judge, there was some rustling in the background. I didn't hear the date. October 15th through when for the trial date?
November, October 14th. Oh, that's McLeland.
14th.
To November 15th.
Okay, thank you, Judge. Apologize for that.
I believe there are 2, maybe 3 motions to suppress that are still pending. I know one I just got and the state hasn't responded to, so you've got your 10 days to respond.
This is 7 days before the trial. No? Yeah, 7 days before this trial we're supposed to set. How do they have 10 days to respond to something? I'm saying, though, these little tidbits shows me she was going to force the defense to drop the speedy trial. Because, yeah, they got 10 days to respond to one of these motions to dismiss. But if the trial is going to start in 7.
Okay, Nick, I know this isn't your general area of practice, but how common is it for judges because we saw this in the Karen Reed case, where Judge Cannoni was like, we're not going to do this in limine. Let's see where the trial takes us, like choose your own adventure to, wasting time shenanigans.
I've seen in a lot of cases when it comes to, because motions in limine, they can more or less not do almost every time, because you don't know what witnesses are going to say that might open the door. So they can't do a definitive. What they can do is they make a ruling with a stipulation, we don't know what's going to happen. So you can refile it. That, at least that's my experience covering trials for Christ, not almost 3 years now in a couple of months.
Yeah, because all the ones I've seen, they'll say like, no, this isn't set in stone. I haven't made a final order, but this is kind of where I will consider the door being kicked open, and I might give you a little wiggle room.
Yeah. In the Donna Adelson case, they had a final pre-trial.
I need to get back into that one. She is a crazy bitch I just love to hate.
Yeah, but she had better defense attorneys than Charlie had. They actually got everything from the divorce proceedings out. They can only show as a demonstrative, look at this big file. It was contentious. That's it. They cannot give examples because the state has to prove that Donna actually saw the filings. So only the things where they have explicit emails where
Okay,
she
so I
and
was wondering if the
Wendy are
emails.
discussing the different filings. Those they can use, but not the
Okay.
entire thing, which was different from Charlie's, where they're more or less, well, here's this, just piled through it. So she has better defense attorneys, I must say. But what the judge there said was, with the divorce and custody battle, he said, as of now, no. But if your client starts testifying and it's brought up in direct examination, then they can use that for rebuttal. So he was very specific with that, more or less warning them, if you're opening the door,
Yeah.
things are getting in. Yeah, what is YSL? The Young Thug RICO trial, the longest trial in Georgia history. That is the YSL trial, which I covered for 2 years of my life.
2 years?
Yeah. And now we have the civil case where Young Thug is trying to get his stuff back from the state. Which some of the stuff is actually lost. They're on the itemized list. We have done this. We took this from the house. And then, oh, it's gone.
Like Karen Reed's Lexus?
Yeah. But yeah, there's a civil asset forfeiture hearing soon in the Young Thug trial. Ms. McLean, Judge, I can tell you the plan with there was I'm sorry, I don't know if it's a third or fourth Frank's motion filed. The state's intent, given that the trial date, we expected the trial date to start on Monday, was going to rest on the previous responses filed, but
Okay.
the state will take another look at the most recent motion to suppress filed and then draft the response quickly, Judge.
What?
Whenever the court can set it, Judge, we can look at our calendars, but whatever works for the court.
We were supposed to be available to the court May 21st through the 23rd, so why don't we set the motions to suppress for then?
She just loosened up 2.5 weeks. They could have motions hearings for 2.5 weeks because those dates just opened up. No, 21st to 23rd. Just those 3. I tell you guys, all of this was pre-planned to force the defense to drop the speedy trial motion request. All of it. Mr. Rossi, yes.
We'll set aside 3 days for pending motions, May 21st through the 23rd, so that can be the motions to suppress. I know there was a second one, I think maybe a third motion to suppress, as well as the state's motion in limine that we can resolve at that time as well.
So, Judge, is the court referring with the motion to suppress? You're including the Franks. I think there's 2 Franks motions pending and 2 motions to suppress. And the pending motions basically?
Not the Franks hearings.
Okay.
Not the Franks, just the motions to suppress and the motion in limine.
Yeah, this is her telling there won't be a Franks hearing.
No.
Ms. McLean, okay.
Are there any other pending motions other than the Franks motion that you haven't replied to, Mr. McClelland, that the defense has filed that you wanted a hearing on?
No, Judge. There's only 4 Franks, and I pulled it out. It's the 4th Franks motion the state has not responded to. Was going to respond to that orally today, given the short trial date. The only other motion, I think there's a motion to compel, perhaps filed by this defense. And then last night, late in the evening, Judge, I filed a request for a pretrial ruling on admissibility. I would ask the court to consider hearing that on the 21st through the 23rd as well. I don't think it'll take long, but I would ask the court to consider that as well. It was filed last night. It may not have been accepted yet by the court.
It has not. It's not in the...
I didn't think it would.
It's not in the file.
It was late last night when I filed it, Judge, so
What was it? What's it called?
basically we want a ruling. We got some documents we'd like the court to review and rule on their admissibility. There's some pretty important documents to the state. There are incriminating statements made by Mr. Allen, and so we'd like the court to review those. I'd like to give them to the court under seal because they're pretty incriminating, and so I would like the court to consider those and give us a ruling on whether or not they could be admissible at trial. I can refile it with the exhibit sealed, or I can present those to the court today under seal. I have not talked to defense about that at this point.
You can just give me the sealed documents, but the motion is, again, it hasn't been accepted yet, and obviously the defense hasn't seen it.
There's nothing in the motion that needs to be sealed, Judge. I just didn't attach the exhibits to the motion because I didn't when I filed it. I wasn't sure the process to make sure they were sealed, and so I just didn't want to file them. But I'd like to present them to the court under seal so the court can consider those in conjunction with the IC code that we cite so that we can talk about that on the 21st or 23rd at some point.
Okay, does the defense have anything else?
Judge, just an inquiry about what's going to happen with Mr. Allen. His movements and location and housing circumstances are, we are unaware of what those are. What's the court anticipating moving forward? I learned in deposition the other day that he was going to be brought up here, so I don't know what. So is he going to be in Tippecanoe County? Is he going to be here? Is he going to go back to Pendleton? Or
If you really want to have this discussion in front of everybody, I'm happy to do that. But for security reasons, I don't think that's appropriate, Mr. Rossi.
well, if the court would be inclined to email us and give us,
I'm not emailing any longer because, again, my emails continue to end up in people's pleadings, and I don't think that's appropriate. So again, if you would like to have this conversation in front of company, I'm happy to do that, but I don't think it's advisable based on security issues for Mr. Allen's safety.
okay, we can have that conversation in a setting that's more confidential. I'm okay with that.
Thank you. Anything else from the state?
I don't believe so, Judge.
All right. Then we'll see you in court. Be prepared, and we'll do May 21st through the 23rd for 3 days straight, starting at 9 o'clock and ending at whenever we end. So be prepared.
In Carroll County, Judge?
I'm sorry?
In Carroll County.
In Carroll County, be prepared on the motions to suppress, the motion in limine, the motion for ruling on admissibility, and that's all I have so far, and the motion to compel. I'm sorry. All right. Thank you very much. Jody, you can go off record.
Thank you, Judge.
This just had to get that last little
Thank you,
scotch
Judge.
of nose.
Thank you,
Just
Judge.
like, I love you, Mommy.
Thank you, Judge.
He should have been named Norman McClelland. Judge Gull's first name is Norma. Makes sense.
This concludes the proceedings at motions hearing conducted May 7th, 2024 in this cause. Which one is next? Yeah. 21st to 23rd of May never happened.
Working is hard.
So there were, I believe that's when all of a sudden I'm not sure what date she denied the Frank's motion, but she did on several occasions because the defense refiled it. She denied hearing. She just made a bunch of, no, fuck it, denied without hearing.
Yeah.
So the 21st to 23rd of May, gone.
Yeah, it's just no care was given by this judge. And it's not only evident in this, but the fact that defense attorneys had to basically hunt her down to get her to approve their pay.
Yeah. At this point in time, May, they hadn't been paid for over a year.
No, and wasn't at this time Gull on some sort of sick leave? Like we were unsure whether she was coming back to even try the case.
Yes, yeah, we were all hoping.
Her appendix took one for the team.
Yeah. Yeah, as Skinner says, she denied without hearing or reading. Yeah, she never cared. She went to the hospital and was admitted. Yeah. Just a little bit more sickly. And this could have all changed. Yeah.
Well, yeah, not to mention the Supreme Court of Indiana had a chance to rectify this when they saw a judge acting with abandon without any, sense of procedure or anything. They had a chance to nip this in the bud and make Indiana look like we care about, fairness, about constitutional rights, about even the appearance of looking like there's bias. But we didn't because we suck.
Yeah. This pisses me off. Let's see. What was the motions hearing? Rossi, Baldwin, and Auger.
All right.
Yeah. All right. Let's continue with the next
Okay.
one. Let's get through. Just let me know when you need a break or when you need to take. Oh
I've-
no, your all of your kids are all off canoeing or
Yeah,
rearranging an Indiana river.
I've got about 20 more minutes because then I'm going to start making brownies and stuff for the hordes coming back.
Ah.
And drinking. I'm going to be real honest.
Okay. January 22nd, court having the defense motion for Frank's hearing. The memorandum in support. Yeah, that's the first. Then they made 3 more supplements for the Frank motion. Supplemental. So she already, but January 22nd, 2024, and she denied it on January 22nd, but they are still talking about it. So the March 13th is Frank's 2. Yeah, so that was the first. Then they went Frank's 2, Frank's 3, and Frank's 4. And she denied them all without a hearing.
Yeah.
Thank you, Mikus. Thank you.
Thank you.
All right. We have 20 more minutes. Proceedings.
All right. Oh, yeah. I was just reading the court. I'm getting in character. All right. Well, good morning, everyone. I apologize we're a little late. We got a later start than I thought, and in typical Hoosier fashion, there's a lot of construction that I wasn't anticipating. So we're here for all of our motions, the pending motions that have been filed. I sent counsel an email, and you all responded appropriately, so I appreciate that the schedule I proposed was going to work for you guys as well. So I anticipated we would do the motion to vacate the safekeeping order first that was filed by the defendant. The defendant then filed a motion to compel and motion for sanctions, and we can take that up at that time, and the motion to dismiss. I figured that would probably get us through the end of the day would be my guess. I mean, I don't know what kind of witnesses y'all have or argument or anything, but just based on the pleadings, I figured that's a good stopping point at the motion to dismiss. I know the motion to suppress and the motion to suppress the second statement are pretty meaty, and I figured that would be all day tomorrow. Is it safe to expect that would take the entirety or the entire day then?
Yeah, folks. In the May 7th, they wanted her disqualified. She denied it. Because apparently in Indiana, it's the same judge who tells them, no, I didn't do anything wrong.
Yeah.
Yeah. Attorney Bradley Rossi. I think so. I mean, that's my impression. I talked to Ms. Diener a little bit this morning about kind of what her approach will be on the suppression, and feel like based on what she told me and what I know about my presentation, that'll probably take probably half a day to do the suppression.
Okay, at least.
And maybe the other half would be the second one.
Okay, yeah, because we've got two of them, the motion to suppress the second statement, then the motion to suppress.
Judge?
Your Honor.
So the answer is yes, I think most of the days.
Okay, Miss Auger. I'm sorry, Your Honor. In terms of the second motion to suppress, I don't think it's going to be half a day. And just for housekeeping measures, if we finish those motions to suppress tomorrow, would you like us to get started on the motion in limine, or are we going to... There's a motion for admissibility and, which kind of ties in, I think. Motion in limine, it does. I think it's kind of connected, yeah. So just for housekeeping measures, if we finish with those three motions tomorrow, are we going to move right into the limine, or do you want to... That would be my intent, if we're ready to do that. If we're not, I mean, we've got 3 days, so I'm trying to be kind of flexible with your time and the court's time. It's kind of not a gift when you're giving yourself more of bullshit time. Like,
Yeah.
I love me enough to waste your time. Okay, we'll discuss that. I just want to make sure that, okay, we're not wasting any of your time or anyone else's time. Okay, thank you.
Judge, the only other thing I would add is that, the state filed a motion to dismiss the first motion to suppress.
Correct.
We assumed that it was going to be included in the motion to suppress.
Yes.
Even though it wasn't specifically listed in your motion. So I just wanted to be clear with all the parties. We intend to argue that within the motion to suppress, the first motion to suppress as well.
Correct.
Okay, thank you, Judge.
That was my intent, because that was your motion specifically addressed that motion to suppress.
Correct, Judge. Correct, Judge. Okay, thank you.
So, okay, so with all of that, with the little housekeeping things taken care of, are we ready to begin?
Yes, Your Honor.
All right, so let's start with the motion to vacate the safekeeping order, please.
Call Tony Liggett, Sheriff Tony Fartface. Witness sworn. May I?
Yes, sir.
Thank you. Questions by Mr. Rossi. What's your name?
Tony Liggett.
And Mr. Liggett, tell us your position with the law enforcement community is.
I'm the Carroll County Sheriff.
Okay, and in that, how long have you been the sheriff?
1.5 years.
And is it fair to say you were not the sheriff when Mr. Allen was arrested back in October of 2022?
That's correct.
It was Sheriff Toby Lazenby who was the acting sheriff at that time?
Yes.
He still actually works for your department, is that correct?
He does.
Are you in charge of the care and custody of Mr. Allen, with the exception of the fact that we have his safekeeping order in place?
Yes.
And do you acknowledge that your office filed a request to relinquish jurisdiction of Mr. Allen back in 2022?
Correct, yes.
And did custody of Mr. Allen was relinquished to the DOC?
Yes.
And do you acknowledge that occurred without Mr. Allen having a hearing on the matter? It just basically, there was a motion, a notice filed, and there was an order signed by the sitting judge.
I believe that's how it went, yes.
And basically, he got shipped off to Westville. Is that correct?
Correct.
And were you aware, when did you become aware that he was placed in solitary confinement at Westville?
You mentioned it in a deposition to me.
And was that in the spring of roughly 2023?
That might be right.
Maybe the summer of 2023?
Somewhere in there, yeah.
And are you aware that there have been attempts by us to try to get him moved out of the DOC into one of the local jails?
Correct.
And did you ever go to Westville and visit Mr. Allen's cell?
Visit his what? I'm sorry?
His cell, his unit up there.
No.
Are you aware that he was moved to Wabash Valley in December of 2023?
Sounds right.
And have you been down to Wabash Valley to visit him and just monitor the circumstances down there?
No.
You're aware that we asked the court to vacate the safekeeping order.
Yes.
And you and I, frankly, have had some discussion about this, even in the hallway.
Yes.
Tell the judge what your plan is in terms of housing Mr. Allen. Maybe she already knows, I don't know that. But tell her what your plan is in terms of housing him over the next couple of days while we participate in pre-trial.
Ed Schroeder, the sheriff of Cass County, has agreed to house him during the hearing. They're going to transport him to Carroll County Courthouse for us, and then we will take him back to Cass County.
Okay, and so while he's here, as he is right now, is it your intention that you would be responsible for his custodial circumstances during the proceedings?
Correct.
And were those arrangements made in advance? When were those arrangements made in is probably a better question.
They were made for the previous hearing, and they were just reaffirmed for this one.
All right, excuse me, I'm having some allergies. So do you believe that these same circumstances can be maintained with Mr. Allen beyond the pre-trial proceedings until we conclude the trial in this case?
I think it's possible, yes.
Have you talked to Sheriff Schroeder about that?
Yes.
And have those discussions even involved the finances that would be associated with housing him in another county?
Yes.
Okay, and transportation, is that a big part of that discussion?
Correct.
Is it fair to say, is it accurate to say that Sheriff Schroeder has asked for the assistance of one additional state trooper and a vehicle to assist with the transport?
Correct.
And is that something that you've been able to accommodate?
Not yet.
Is that something you think you're going to be able to accommodate?
I believe it could be accommodated, yes.
And in fact, we took your deposition back in May of 2024, right?
Yes.
And at that time, there were some questions posed to you regarding these transportation accommodations.
Yes.
And do you acknowledge that you essentially told us in the deposition, us being Mr. Baldwin and I, that you had believed you worked out the transportation issues associated with this now?
Correct.
And that involved getting some assistance from the state police.
Correct.
Do you agree? Well, let me ask you this. Do you think that there's any circumstance that exists at Wabash Valley which would suggest that Richard Allen is in danger of serious bodily injury or death?
At Wabash Valley?
Yeah.
I don't know the circumstances down there.
Okay. And are you aware of any circumstances that exist where he's a threat to someone else because of something he's done while he's being incarcerated?
I'm aware of anything personally.
So your idea of getting him moved to another facility is mostly just a logistical issue, right?
Somewhat, yeah.
And if he were to be moved to Cass County, are you comfortable that the facilities over there are adequate to house him while we await this trial?
Sheriff Schroeder believes they are, so I trust Sheriff Schroeder.
Have you been to the jail down there?
It's been a long time. I haven't been there since their addition, but I've been there in the past.
Are you aware that we're graced with a new second half of the facility in the last year or so?
Yes.
And that there's a couple of hundred more beds that are available there?
Correct.
Is it your understanding that's a pretty modern state-of-the-art facility in terms of jails?
Correct.
And are you comfortable in talking with the sheriff that he has an adequate confinement circumstance there to house Mr. Allen?
Yes, I believe he believes so.
Does he have the right cells, the right type of cells and isolation and circumstance to assist him?
Correct. He said he has, yes.
So you don't have any problems with that? You have one problem?
I do have one problem.
We talked about this in the hallway.
We did.
Tell the judge about that.
So, under normal circumstances, we house people at Cass County already, and if there's a problem with an inmate or anything medical occurs, Cass County Jail picks up the phone and says, "Come get this inmate, take him back." I don't believe that would be something we could accommodate if that were to happen. So my fear is if we vacate the safekeeping, that might happen. So I guess if I have a question, can the safekeeping just still be in place but changed from DOC to Cass County?
So what you would want the judge to do is essentially modify the last paragraph of the order to reference that he would be transferred to the custody of Cass County. But if those circumstances would change, that the DOC would be the backup, essentially.
Correct.
You could also just petition the court and ask for it to be modification, right? That's also an option.
I could, but that I'm sure will take a bit of time for that to happen.
Well, the last time you petitioned, it happened immediately.
When Toby Lesenby did, I think it was relatively quick, yes.
I don't have any further questions.
Mr. McClelland?
Thank you, Judge. So, Sheriff Liggett, if the safekeeping order is vacated today, Richard Allen comes back to Carroll County Jail, correct?
Correct.
And is put in Gen Pop with the other inmates in Carroll County Jail because we don't have solitary confinement there.
No, we do not have any kind of solitary we have a padded cell, but it's not housing.
There's no toilet in there, there's no shower. It's basically a padded...
It's a padded cell.
Square cell. And so at that point, you absolutely could contact another county and see if they would house him.
Correct.
Have you done that in the past?
Correct.
But if he's housed in the Carroll County jails, in the jail, or do you have concerns about his safety?
Yes.
Do you have concerns about your ability to house him in the Carroll County jail?
Yes.
And so is it your opinion that the safekeeping order at this point is still necessary?
Yes, I believe the safekeeping is still necessary.
And do you have any preference of where he's housed at this point?
No.
And so do you believe where he's housed now in the Department of Corrections is adequate?
Yeah, I have no reason to believe differently.
Do you know if that they have medical personnel down there to be able to take care of any medical needs he may have?
Correct.
Do they have mental health personnel there that may be able to take care of any mental health needs that he needs?
Correct.
And they're able to transport him back and forth to the hearings, is that correct?
What? Say that last part again.
When he's housed in DOC, who's responsible for the transport back and forth to the hearings?
The state police have been taking care of that for us.
And so is it your testimony today that you want him housed at Cass County?
I don't care where he's at. He can't be with mine, but the safekeeping should still be in place.
Okay, I don't have any other questions, Judge.
Mr. Rossi?
Do you agree that he's being held currently in a solitary confinement setting?
I've not been told that. I don't know.
What about when he was in Westville? Do you agree that he was held in a solitary confinement setting?
At some point, yes.
You're aware that Warden Yalipu has testified in this courtroom before regarding his detention circumstances, right?
I know he testified, yes.
And you're generally aware that he basically have been living in an 8x12 cell for the past 15 to 20 months, if I did the math right.
It's about the same size as our cells.
Okay, but you're aware that's the circumstance.
Okay.
And that he's been cut off from contact with other inmates other than just yelling through the doors.
I assume that, yeah.
Okay, now in terms of, you said earlier that you thought that his current detention circumstances were adequate. I think the word was the word that was used. You recall that just a few minutes ago, Mr. Leland questioned you?
Correct.
You and I talked about solitary confinement when I deposed you back in May of 2024, didn't we?
Yes.
And did you acknowledge at that time that there are some very specific rules regarding solitary confinement?
Yeah.
Within the prison or the jail setting?
Correct.
And you advise that you have standards which are actually offered up to probably through the Sheriff's Association, on how to detain people in solitary confinement and the length of those stays.
Yeah, it's through the Department of Corrections.
So it basically, you adopted the DOC standards.
Well, they set the standards for us, yes.
And you acknowledge that there is a threshold within those standards that basically says that 30 days is kind of the maximum limit that one should be solitary confined unless there's some exceptional circumstances.
I believe the rule is that 30 days being a maximum, then they have to, they have to have some sort of administrative hearing to continue it.
Fair enough. That's what you told me at the depot, right?
Correct.
And do you agree that the reason for that rule was because holding someone in solitary confinement could be detrimental to their mental health? Judge, I'm going to object at this point. I'm not sure how this goes into the safekeeping, or whether or not he's in danger in Carroll County Jail or not, or whether or not that safekeeping should be vacated. Judge, because Mr. McLeland asked Mr. Liggett if he thought his current circumstances were adequate, and his answer was yes. Our response is that they're not adequate. That's part of the reason why we asked the court for assistance. So I think it's relevant.
Overruled.
Thank you. So you acknowledge that this threshold of 30 days exists, right?
Yes.
And one of the reasons why that exists is because it's known in the industry that holding somebody for longer than that in solitary confinement could be detrimental to their mental health.
I'm sure it could be, yes.
And he's been alone now for the better part for a year and a half, right?
I'll take your word for that. He's been held, yes. I don't know where that entire time.
Do you have any reason to believe he's in Gen Pop down in Wabash Valley?
I highly doubt it.
I don't have any further questions.
Mr. McLeland?
Is he going to be in solitary confinement if he's housed in Cass County?
He's going to be in a segregation cell, yes.
By himself?
I assume so.
Okay, I don't have any other questions, Judge.
All right, thank you, Sheriff. You had more?
May I ask another question or two?
Sure.
Have you seen the cells at the new jail at Cass County, the solitary cells?
I have not.
Have Sheriff Schroeder explained to you what those cells, how they're set up and how they're structured?
No.
You're building a new jail here, right?
Correct.
Have you looked at the designs for your new jail?
I have.
If I told you that they're the same down in there in Cass County, situated such that there are some rooms in solitary cell with access to the day room, would that sound consistent with your plans here in Carroll County, Sheriff?
No, ours are different.
Okay, I don't have any further questions.
Anything else, Mr. McLeland?
No, Judge.
All right, thank you, Sheriff. You may step down.
Judge, may I approach?
Yes.
Judge, I got marked as Defendants A, an affidavit of Sheriff Schroeder from Cass County. I'd be able to read it into the record, but I don't know that I necessarily need to do that, but...
I'm sorry, you were talking and walking at the same time?
I'm sorry?
Repeat that, please.
So, I'm presenting to the court Defendants Exhibit A, which is an affidavit of Edward Schroeder, who is the Sheriff of Cass County. This affidavit acknowledges that he has communicated with Sheriff Liggett and that there are arrangements that have been made to house Mr. Allen. The affidavit also acknowledges that the facilities in Cass County is adequate to house him through the trial in this case. The affidavit also acknowledges...
Oh, perhaps we could admit it before we start arguing it, if there's any objection.
I move to admit Defendant's Exhibit A. No objection, Your Honor.
All right, thank you. Without objection, I'll show A is admitted. You may proceed.
I'm trying to summarize the affidavit rather than, unless the court wants me to read it into the record. I understand that you can read it yourself. Mr. Liggett, Sheriff Liggett's testimony is consistent with what's in the affidavit, and I actually shared it with him today before the hearing to make sure that, that information in the affidavit was accurate. So we're asking the court to consider the language and the information in the affidavit. I try to avoid having to bring Sheriff Schroeder up here because he got other things going on as well.
Sure.
I have nothing further, Your Honor.
Okay, does the state have any evidence on the motion to vacate the safekeeping order?
Just argument, Judge.
So argument then, Mr. Rossi?
Well, Judge, you know, this to me seems to be a practical problem because in any case, there is a law that actually dictates how those safekeeping orders are issued and whether or not they're appropriate. And that law is IC 353311-1, which says that upon motion by the sheriff alleging that an inmate in a county jail awaiting trial is in danger of serious bodily injury or death, or represents a substantial threat to the safety of others, the court shall determine whether the inmate is in imminent danger of SBI, serious bodily injury, or represent a substantial threat to the safety of others. So basically, there's a process. And what I heard today from Sheriff Liggett is that there are no concerns about whether or not there is any danger of serious bodily injury to him or anyone else. There's nothing in the record that meets any of the standards that are preferenced in the statute. And so, from a purely legal standpoint, I don't think there's any basis for the safekeeper order to be in place at all. The practical side of me understand that you just can't put him in jam pop somewhere. I understand that, and so we try to find an alternative to that. I think the Cass County Jail is an appropriate alternative. Mr. Sheriff Schroeder is on board with that. Sheriff Liggett pretty much said he doesn't care where he's housed. I think those were his words, and so I would ask the court to either modify or vacate the order. Now we're talking, form of a substance, but I understand Sheriff Liggett's concerns about, well, what happens when things go south over in Cass County? What do I do with him? So if that's a concern for the court, then maybe modifying the order makes more sense from the technical standpoint. Otherwise, we'd ask the court to vacate the order, which would then be the cause for Sheriff Liggett assuming jurisdiction over his circumstances, in which case he'd be shipped down to Cass County. Thank you.
Mr. McClelland.
Judge, first I asked the court to take judicial notice of the hearing we had back in June of 2023. It was a 3+ hour hearing where we had everyone testify, including Sheriff Schroeder, and we litigated this very issue, and we litigated at length. And in that hearing, I took some note from Sheriff Schroeder specifically, and what Sheriff Schroeder said is that he's going to be in a cell by himself, 7x9 or 10x8. He's going to have 1 day of rec himself. They only have medical available 12 hours a day, and they don't have them on staff. They have to call them. Mental health facility or mental health personnel are only available 1 day a week. And so it could be argued that his situation in Cass County going to be more dire or worse than what he is at the DOC. And I think that's what the court found at the last safekeeping hearing that we had. And so if the it's such absolute bullshit.
I mean, no mental health care would be better than what he got.
Yeah. And what happened back in 2023, then he was in the back end of an active psychosis. This is a year later. He's no longer in psychosis. His medication, because they got everything they wanted, they got out of him, the false confessions and everything. There's no need. Well, there is need because everything in those supposed confessions are garbage. There's no details about the crime scene. The fake van, which Brad Weber lied about twice. Brad Weber lied first back in 2017. He claimed that he was out servicing ATMs because he didn't want to be associated with the crime. But then 7-8 years later, when it was convenient, I drove past there. I was there roughly at the time of the murders when it was convenient. Problem is, he claimed he was there 2:30 driving past. And then a video emerges after trial that puts him there at 2:44.
And these are such simple things. Again, Mr. McClelland, I was going to give you a chance until I realized you're just a douche. That being said, you don't think I wanted Richard Allen to be the guy? I wanted us to catch the guy. I mean, I'd been waiting on pins and hooks, and ever since we got getting told, like, just believe us, we're totally working hard on this trial, on this case. But the case wasn't there.
Yeah.
And
It never was.
no,
I mean,
from
that-
the probable cause affidavit, there were issues in this case.
They had everything they needed to charge Ron Logan because he lied about his alibi, and his phone pinged when he received a text message outside of his house close to the crime scene, and he lied about his alibi. We have Westfall, whose only alibi is his wife, who then left him immediately. Then you have Elvis Fields, who lied about his alibi. Then you have Brad Holder, whose alibi is, well, my time card says I was at work, and then I pinged myself at a gym. You know you can do that without being there? Ping yourself at a certain location.
Yeah.
I can do that with my phone right now, claiming, hey, I'm at Mo's place. Ping. I'm not, by the way. Just to make sure, I'm not there. Look, my hand does not show. I'm not in the same room.
Yeah,
with
I
Mo.
couldn't get Nick to go with the lavender.
So, yeah, this fucking safekeeping order. But I say this, the first Judge Diener's safekeeping order, that was an ex parte meeting. They didn't notify Mr. Allen or his counsel at the time. And I believe the rule is the same in Indiana as it is in Georgia. An ex parte meeting on its face is always prejudicial towards the defendant. And they didn't even find out about the circumstances until shortly before the first motion to vacate the safekeeping order. And that was sadly not until after Rick Allen started making his weird confessions. Because they hid
Yeah.
it from the defense, the circumstances.
Well, they hid that. The way Diner recused himself has always been questionable to me.
Yeah, and now he's, what is it, aunt by marriage, is Diener on the prosecution team.
Yeah.
Fuck you, Dieners.
Well, yeah.
Blah blah blah. Let's see. And so the safekeeping order is, if he goes back to Carroll County in Gen Pop, they already said he wouldn't.
No.
It's up to they said no. We are not placing him in Gen Pop. Lying sack of shit. It's up to the sheriff whether or not he's moved to another jail, and that's a discussion with the sheriff. And so vacating the safekeeping order, the state does not believe is appropriate. The sheriff testified he's in danger. He feels like he's in danger if he's in Gen Pop. And so vacating that order, the state's opposed to that. That leaves us with, can the court dictate what facility is held in if the safekeeping is kept in place? Safekeeping is not something I deal with on an often basis, Judge. So I don't know. I assume the court can do that, can order someone held in a certain jail. But why are we moving where he's at? The only thing I've heard is it's closer to my office. I want him moved here because it's closer to my office. He never mentioned that in this hearing. That was the previous one.
Well, not to mention, McClellan doesn't have to drive 2 hours away, have to try to talk and converse to his client through a steel door, not be able to show exhibits to him, and then have everything taped or observed through open doors.
I haven't heard any different argument than what we had back in June of 23. So what has changed from then till now, to warrant a modification of the safekeeping hearing beside that it's more convenient for Mr. Rossi? No. The evidence to all the case, I presume, is still in Mr. Baldwin's office, where it's held now is closer to Mr. Baldwin's office. And so I don't understand what the reasoning is for the modification. In Cass County, it's going to be in essentially the same situation. It's going to be in solitary confinement. See? Even McLeland says it's solitary confinement. So any of you fuckers who claim it was in solitary confinement, I challenge you. Again, I've said this before. Sign the waiver, give me a week, and I can make you confess to these murders. So, by the way, I've done that, at least 20 or 30 times now to different trolls. Non-takers, oddly enough, because they claim, oh, it wasn't that bad. Oh, really? Let's try it. No.
Yeah.
Unless the defense is arguing that he should be in jail pop. I don't think that's the argument. I think the argument is that we want him in solitary confinement, just not in DOC. Oh, that's a nice straw man. We want it in Cass County Jail because it's right across the street from my office. I trust the jail is there and I can meet with him when I want. How is that a bad thing, you fuck?
Isn't that something that's supposed to be fairly, I don't know,
Yeah.
the base, the very lowest common denominator required for a defense?
Yeah. That seems to be the argument from the email Mr. Rossi sent. And so I don't know, again, let's go back to the same thing. What has changed since the last hearing that would warrant a modification? How about the new facility in Cass County, where the isolation cells, even by themselves, are attached to a recreation room? So what they do is, basically, they have these rooms, and then all of them are locked except one. Go out in the rec room by themselves, fixing anything, back in cell. It's not... Again, the state has no preference where he's at, judge. Want him to be safe, want him to be able to appear for trial. But again, with the testimony we heard today, I don't know what has been the change in circumstances to warrant any kind of modification. So that's where the state is at, judge.
Anything else, Mr. Rossi?
Judge, the substantial change, to the extent that there is any standard here, is that he's 200 miles away from my office. He's 2 hours from Mr. Baldwin and Miss Auger's office. There's been a substantial change since we were last here. Yeah, he was moved to a prison further away than Westville.
Yeah.
The other circumstance that's significant is that it does have a Sixth Amendment right to counsel. And I believe, to the extent that it's difficult for us to access him, that right in some ways is infringed upon. And it's not that I can get in my car and drive 3 hours one way and 3 hours back, because the expense and the burden that's been putting on the county here in Carroll is also a consideration. And I wasn't opposed to him being moved out of Westville. I felt like that was one of the worst places on the planet. I think the court will eventually see that as we move forward with other hearings. But at the end of the day, there's been changes, and that is the fact that he's been moved even further away. For Mr. McLeland to sit here and say that he has no preference about where he stays, but then objects my request to vacate the safekeeping order is, contradictory approaches. And so we're just trying to find a practical situation where we can have attorney-client relationships, where Mr. Allen will be closer to his family as well. Obviously, there's that situation. He's 250 miles away from his family at this point. So those are all changes in the circumstances, and we'd ask you to take those into consideration, as well as the transportation issue that Sheriff Liggett has now said, and even told us in May at the deposition, that he has resolved. Thank you.
Anything else, Mr. McLeland?
No, Your Honor.
Well, I guess my question, gentlemen, is does the statute give the court any authority to modify the safekeeping order to a county jail? Now, my understanding of the statute is that it is a commitment to the Department of Correction for safekeeping. So does the statute, or do you have any case law that permits the court to do what you're asking the court to do?
May I?
Yes.
Judge, I'm reading 35, 33, 11.1. And down here in the middle of that statute, it says, if the court finds the inmate is in danger of SBI, or death, or represents a substantial threat to the safety of others, it shall order the sheriff to transfer the inmate to another county jail or to a facility at the DOC designed by the commission. So there you go. I think that satisfies that. Thank you.
All right. I will take the motion to vacate the safekeeping order under advisement to review the affidavit that has been submitted and Defendant's Exhibit A.
Thank you.
All right. So we completed that portion of our hearing. Are you prepared to proceed then into the motion to compel and motion for sanctions? And do you anticipate evidence on that or just argument? We're prepared to proceed, Your Honor. I would anticipate just argument on that. Now, do you have free time tomorrow? I'm pretty free tomorrow if you want to finish up at least this hearing.
Yeah, I will make free time tomorrow because it is easier to do this to people. Much easier. Let's see.
I don't know. I think you make a lovely Miss Auger.
Miss Auger, we are prepared to proceed, Your Honor. I will just anticipate just arguments on that. The court. Okay, because it's 11:42. We are at page 101.
Sounds good.
Yeah. So, folks, we will continue this tomorrow. Should we? What time do you have?
We have some family in, so let me get a good time. Let me make sure my family comes back from the kayak trip.
Yeah.
Let's not put the horses before, or the cart before the horses.
We will check the news for, in sudden events, the direction of this river has changed. We do not know what happened. And then you see a couple of canoes and people just running away.
Youngest, most feral has an eye patch.
Laughing wildly.
Pretty much.
Mommy, guess what I did? We saw the news.
It was called a mutiny, and you're being court-martialed, which I didn't know was a thing, but congratulations.
Oh.
They're not going to the sewage river for the first part. It's Turkey Run, so hopefully they'll bring back a turkey.
Yeah.
Or a bald eagle. I mean,
you really can't take anything out of the question. Mommy,
no,
we have a new pet, beaver.
Hey, if it's a raccoon, I say we go for it.
All right. So, folks, I will let you all know in good time before we start this again tomorrow.
Yes.
Yeah. So, with that, thank you to Oksana. Thank you so much. Thank you to Tony. Thank you so much. Thank you to Dave. Thank you so much. And
wait, is that the cheese that you put into coffee? Because I have a couple questions. And how is that not against the Hague?
Cheese in coffee?
I read a story on Mornings with Mo about there's some kind of Swedish cheese that's you put in coffee, or maybe that was Norway. To be honest,
that sounds like Norway. They are weird.
Or Finland.
Yeah, can be Finland as well. We don't put cheese in our coffee. Heavy cream, yes, but not cheese. All right, folks. Thank you. Thank you for allowing us to do this. And I'm going to send you off with the free Rick Allen song. But remember, hug your family unless they're crap. Then screw them and give your love to the people who deserve it. Okay?
Absolutely. Bye, you guys.
Bye-bye.
Down in the shadows where the courthouse stands, a gavel cracks a fading hands. Judge Gould, they whisper with a crooked grin, played the game where justice don't win. Free Rick Allen, let him go. Chains on the innocent, don't you know? When the truth's been buried and the lies unfold, the fire in the people burns hot and cold. Prosecutor Mickelin, with his papers tied, wrote the tale that never saw light. Twisted words in a room of stone, left Rick Allen to stand alone. Who will answer? Who will pay? The sun don't rise on a judgment day. Free Rick Allen, let him go. Chains on the innocent, don't you know? When the truth's been buried and the lies unfold, the fire in the people burns hot and cold. Officer Holman, eyes like frost, drunk on power, the line got lost. Lock the doors, keep him inside, for justice limps where his footsteps stride.
Oops.